Welcome back. So that controversy concerning the letter circulating from the CJN and 14 Supreme Court justices, which is leading to this disquiet in the Supreme Court. Mr. Ubani joins us next to weigh in on that matter. He's the chairman, Speeder, and former second vice president of the NBA. Good morning, and thank you for coming
Chamberlain,
on the
thank
show
you.
today.
Good morning.
Well, taking a look at all of this back and forth, even though the CJN says you're just dancing naked in the public. So for you, did you expect this, that at some point this was always going to break? Because lawyers, we imagine, already knew or had an idea of what was going on. But for several others who didn't, how did you see this letter when it hit the airwaves?
Yeah, it's clearly unprecedented. This is the first time in the history of the Supreme Court, 58 years, for justices of the apex court to openly express their grievances to the knowledge of the entire public. You know, it is shocking, but it was long expected that there is a rot in the system. What
was long expected?
I mean, the issue of the rot in the system must one day become a matter of public knowledge so that we can really address it. The administration of justice in Nigeria has suffered.
Is this about general rot in the system or the welfare of the justices of which the CJN is not handling matters, right?
It's all comprehensive. The general rot includes the issue of basic infrastructure, including the issue of their welfare. I mean, when a judge who ought to go on some of these international seminars, you know, that really will brace them up in the 21st century does not have that opportunity. It can be very frustrating. And most of them were complaining of rickety cars. We have judges in this country that have to jump Okada in order to go to work. Huh? Yes. They don't have any car.
Judges?
Yes.
Magistrates?
Yes. Even magistrates, even some judges.
Supreme Court?
No, not Supreme Court. Not to the Supreme Court level. You know, we are talking about the general, rot in the system. It's been there. And it has affected administration of justice. The stakeholders, the litigants, the lawyers, everyone has been suffering, but we kept quiet. You know, I think for the first time, these judges, had to brace up to speak out. Because according to them, all the effort they made to have these issues resolved internally, they couldn't get any solution, and so they have to speak out. So that now I'm sure it's going to be addressed.
You know, in the CJN's response,
yes,
which shocked quite a lot of people, as you said, this is the first time we're seeing this. He said that, well, this was meant to be a personal letter, but it found its way to the public. And looking at the original letter now, which is said to have found its way to public, the justices said, God forbid the day that our internal issues become a matter of national discourse. It will be a catastrophe better imagined, and said your lordship must therefore act before it is too late. So again, just to reiterate, is this good for the judiciary as a whole that this has finally come out, or does more damage than good?
If you look at the content of that paragraph you just read, and I'm sure this letter was written without any intention of making it public. It was a personal letter that is written to the CJN to address some of the grievances which they have complained over time. But how this private letter found itself in the public domain is something that we cannot, vouch for. But the point is that it has become a public knowledge that we need to discuss it and then find a practical solution to it. There are issues in the judiciary, and that is the truth. The administration of justice has been suffering. I have a case in the Supreme Court since 2013, and we are in 2022. That has no date. So also all over, in Court of Appeal, all over the country, many years. It takes an average of 5 or 6 years for you to get a date.
So this is not peculiar to the tenure of this current CJ, and it looks like something that has been on before now.
Yes, but what they said in this letter they wrote is that there has been an improvement in the budgetary allocation, but there has not been a corresponding improvement in their welfare. That even when the budgetary allocation previously was not up to what it is now, they were still enjoying some measure of all those things they complained about. They're now lacking. And this is what makes this particular letter a bit peculiar. You understand me? There has been issue of insufficiency in funding, and we have been saying it, that we need to fund our judiciary if we really want to have an efficient administration of justice. We've been saying it. But in this particular letter, they are saying, well, there has been a slight improvement in budgetary allocation with cash back. So how come those things we are even enjoying when things were not okay? We are not even enjoying it now when there has been an improvement in it. So that is what makes this particular letter a bit peculiar. And I think that is a matter that the CJN should address and ensure that those issues that they have raised are really adequately attended to, especially on issue of going for international seminars, issue of their cars, issue of accommodation. Those who have been appointed how many months ago have not been given accommodation. The CJN in the reply said these things are going to be addressed. So I think that is a matter that should be settled. We shouldn't, we're not going to take side in this issue. We commend the justices for raising the issue, because sometimes what killed this nation is that people will have issues that they keep quiet over it. It's only when they're out of office they begin to complain. No, we should internally address some of these issues that are impeding the progress of this nation and see what we can do to get this country working. No aspect of Nigeria's system is working. And many people who are there will keep quiet. It's only when they get out of the system they now begin to provide solutions. So my take is that we commend this. But we'll be happy that if these issues are addressed, and then the harmonious relationship that has been fostered over time maintained. We don't want a situation where the judicial officers, which is apex corp, we have issue of disharmony. We will affect administration of justice generally, and it's very important.
Mr. Ubani,
Yes.
58 years is a long time. You said this is the first time it's happening in 58 years.
That's correct.
You know, and these are Supreme Court justices. I believe they're referred to as my lords temporal. You know, are you disappointed really about how this is being handled? You know, the letters of the Supreme Court justices are private, were supposed to be private, but the response of the CJN has not been private, and he has used very strong language. What precedent really is this setting, you know, for the judiciary?
I must tell you that any stakeholder in the legal profession will be sad at the development of this relationship. But if you look at that letter, there was several times they've made effort, you know, to have audience with the CJN, according to them. But eventually that audience was granted sometime in March. And then subsequently a committee was set up to aggregate all their grievances, which they passed over to the CJN. That was in March. We are now in June. And according to them, none of those issues have been actually addressed. That now precipitated the second letter, which ordinarily should be private, but unfortunately it was leaked. Are you following me? Now, I would have, if I'm in the position of the CJN, I wouldn't have responded openly with stronger words too, because it gives the impression that there is disharmony within that apex court. You know, the kind of respect that these judges, you know, attract to themselves, you know, by even the lawyers who appear before them, and then let alone the ordinary litigants, you know. So there are things that can be handled in such a diplomatic manner. But since this has become public knowledge, my own take and the advice of everyone who is a stakeholder is that this matter should be addressed properly and handled in such a manner, because there was a prayer point in that their letter that God forbid a time will come where the justices will take a more, what I consider a more adverse, step in redressing this grievance they have just expressed. So what more if the justices now boycott court or carry placards? That would be the worst that can happen to our judicial system. So I think that this opportunity presents a golden one for this issue to be addressed, so that there will be joy and happiness within. Because if they are not happy, there is no way they can dispense justice. And you know the quality of justice, and know that it's an expensive thing. We must get it procured at all costs in a manner that everyone will be very, satisfied. For now, there is disquietness, which what you rightly pointed out, within the Supreme Court circle.
The narrative, the response from the CJN, just as it's been raised now, when you look at all of what's going on, in the first place, you never would have thought judges need to seek audience more than once or twice before you even get a look in. But now that there's I think the body of benchers set up this peace committee, which will be a standing committee, supposed to be headed by the CJN, and then several SANC will be on that particular team. How do you see this playing out? Because already we have an understanding of the mindset of the CJN with its response to the letter.
Yes, they are human beings. They are not infallible because they are Supreme Court justices.
Yeah, but from the principle of
yes,
being a judge in your own matter,
yes,
should the CJN
no, he will not. No, certainly he will not be the one to preside.
But he heads.
Yeah, he heads the yes.
Why
think
head
that
if you don't preside?
no, the best thing to do is that when the matter of this peace thing is being discussed, he will ordinarily recuse himself and allow some other person. That is, there must be a deputy that will actually preside over any peace parley.
But the head can always override the deputy.
No, what I'm trying to say that when this issue is going to be discussed, I expect the CJN to step aside to allow his deputy to preside over the peace parley in order to ensure that he can't be a judge in your matter. This is a matter that there has been a complaint against him by his judges. These are people who are working with him. Most of them have been in the Supreme Court for God knows how many years. So they've passed through many leadership. Of course, you see the complaint that they had been there. And when even fundings were not as much as it is, they have been, getting some of these things they're complaining about. So how come there is an improvement in the budgetary allocation and we're not getting it? So they've been there. They've seen how harmonious relationships have been. So if this issue of peace parley now comes up, I expect the CJN to step aside and allow somebody else to preside in order to arrive at a more harmonious and everlasting peace. Peace that will be everlasting is what we should be looking for at this juncture.
So I'm looking at why there's probably a need for a peace parley.
Yes.
Looking at the CJN's response, it says that, the general public should rest assured that there's no hostility
yes.
or adverse feelings amongst the justices of the Supreme Court as everyone is going about their normal duties. So,
yes.
He's saying essentially there's no hostility. So,
yes.
if there's no hostility, really,
yes.
is there a need for any peace parley? That's on the one hand.
That's
but
right.
Also, I wonder what more can be done. Because, again, looking at the CJN's letter, he said that the Supreme Court definitely does not exist outside its environment. It is also affected by the economic and socio-political climate prevailing in the country, saying that they have been living in their constitutional responsibility. So I wonder what will get better, because for him, he's saying that we're doing the best we can.
Yeah, issues are joined. For us as lawyers, if you look at the complaint of those justices and look at the response, issues are clearly joined. There is there are variants. Oh, I'm not getting this. Oh, due to economic situation. That's the reason why you're not getting this.
And then they said, but your family, you're enjoying
we are doing our best.
People.
So issues are joined. So it is important that a neutral person look into this complaint and address it and ensure that things are done properly. You understand me? Because if it tells you there is no hostility now, looking at it, we're all adults. There is obvious hostility. So we need to sit down and agree that those basic things they complain about must be given to them. It's important. And the CJN cannot in any way compromise that. He knows it, that these people need to be in the best frame of mind in order to give out their best. So that complaint is there. In fact, they said they are meeting today.
But
the four justices are meeting today, meaning that they want to now, in a concerted manner, articulate even this grievance in a more, ferocious manner. So I think that the best thing is a peace parley that can address this issue. Now the CJN is better he listens and makes sure that this harmonious relationship is actually maintained. It is important, and I'm happy with the way he ended the letter, that everyone is going about it, but we know that things are not normal.
From the look of things, there's no acrimony.
Yes, but I'm saying that things are not normal.
So why are you happy with the way he ended it?
Yeah? No, I'm saying, he's saying that, everyone is going about that.
They're mature people. They have to go about it.
He needs to be diplomatic in his language. Because it's also, language is key. The manner he says it also can exacerbate situation. Are you following me? So that particular landing sentence, shows, that, things will be sorted out. That is very hopeful. We are hopeful that things will be sorted out.
Perhaps you should help us understand, how the CJN is in charge of the welfare of the Supreme Court justices. And I ask this because I want us to set it against the backdrop of, events of a few months ago where judiciary workers went on strike, and the complaint was that the judiciary should be put on the first line charge so that the welfare of judiciary staff can be better taken care of. So help us understand how the CJN is in all of this mix.
He's the administrative head.
Okay.
He's the one in charge. He's the head of the judiciary. At the apex, so also the CJs are at the state level. They are the one that, at the first line charge, the money comes, they disburse. and ensure that the issue of welfare of the judges that work with them are taken care of. Are you following me? Just there must be a head. Somebody must be in charge of distribution of the resources. So he is clearly in charge.
So if he's culpable here, which has not been determined,
yes.
we would require an independent auditor, you know, to ascertain some of the allegations that the Supreme Court justices are making.
Let me tell you what transpired. There was this issue, a seminar organized by the Nigerian Bar Association recently, generally to address this issue of administration of justice in Nigeria. Now, during that interface, you know, because stakeholders were involved, including the Attorney General of the Federation, now the issue of funding became a topic. And the issue was, oh, we are funding from the executive side. We are funding you guys. But what we demand is that there is much more needed in terms of transparency. Oh, we are taking aback. The Attorney General was bold enough to speak, look, there has been an improvement in the issue of budgetary allocation, but what is also lacking is that we need more of transparency now in accountability, in accounting what is given to the judiciary. That was something that was revealing. And in my own contribution during that discussion, I said, I hope we heard the Attorney General clearly. He's saying there has been an improvement now in allocation, but we also need some level of transparency by those who are in charge.
So shouldn't there be a fundamental change in terms of the structure, such that this matter never comes up again?
I think some of them are making a plan to probably set up not only one person have been in charge, but maybe a team of committee that will actually be in charge of disbursement of this budgetary allocation at the state level and federal level. That has been the discussion. It's veering towards that angle. Instead of one person being in charge, let there be a team involving some of the judges, you know, when this allocation comes, how do we allocate it with the issue of basic infrastructure, with the issue of welfare, with the issue that has to do with administration of justice generally. Are you following me? So it's an ongoing conversation. I'm saying the issue of transparency, you know, even in the funding system, and then the insufficiency of funding too, because we also have to, you know, place it before the altar of the executive and legislatures. Look, if you want administration of justice, quality one at that, then we must also improve our funding. We must also make sure that these people are well taken care of. I don't know whether you saw a viral video in one of the states where they were removing pool of water from the court. It just rained, and it was like a swimming pool. People were removing, you know, and it's all over. If you go to even my state, there was a time a magistrate just finished sitting, and then went into the chambers, and they this in the building caving, because of issue of basic infrastructure not being taken care of. So if we want quality administration of justice, then we must pay for it. But not only paying for it, we must also insist on transparency, even the little one that is being released to them. These are the key issues we want to address. Funding increase, but in funding, we must also account for it and ensure that it goes to where it's supposed to go.
Makwe?
Indeed, I mean, one is even a little lost as to where to intervene when 14 Supreme Court justices write to the Chief Justice of Nigeria, who is their colleague. I mean, one would say at that level, they are already colleagues. It's just he's first among equals and takes leadership. And we see how you know, matters are resolved in those kinds of institutions. For instance, in the National Assembly, where you know, the Senate President is first among equals. In the House of Representatives, the Speaker is first among equals. There is a manner for adjudicating and resolving things. This matter is so weighty. When you take a look, I mean, the words of the Supreme Court justices in their letter, I'm looking at this, says, Your Lordship, with all due respect, this is the peak of the degeneration of the court. It is the height of decadence and clear evidence of the absence of probity and moral rectitude. These are very heavy words coming from an institution where, you know, even if all of the other institutions are failing, I know people have said that, you know, the courts are not immune from what is happening in society. But if people expect any amount of decadence in the courts, not at the level where Supreme Court justices take up the matter with the Chief Justice of Nigeria. Have we ever, I don't think that in how we have thought about the judiciary of the country, we have ever envisaged that this could ever be the situation in the Supreme Court. Did it ever come up at all?
It never occurred to me that we will come to a level where a thing like this is being debated and even discussed openly, maybe even before the television. Knowing fully well how grave, that arm of government is, especially the Supreme Court you have just made reference to. But there comes a time in your life when you stomach some certain things, and at the time you can't stomach it any longer. The sentence you just referred to came about when they made reference to a particular memo that proceeded from the registrar asking that the court should be shut down every day by 4 p.m. Because of issue of diesel. And these are justices that would have taken proceedings in the court and need to retire in their chambers to write rulings and judgment. And you are asking them to leave the Supreme Court by 4. And they said this is the height of degeneration. We cannot allow this to continue. And as I said earlier, they may have sought, private audience or tried to ensure that these grievances are addressed, and probably it wasn't addressed in a manner that is satisfactory, and they felt that this is the right thing to do by writing. And I said earlier, they may have intended this letter to be private, but unfortunately it's leaked. And so those language you mentioned may have been personally meant for the CJ in order for him to really know that things have been addressed. We preside over our family issues, especially as a father. There are times children also can sit down with their mom, and when the father has become too how do I describe it now, unapproachable, and some of his decisions are regarded as being draconian, they can say, Daddy, let's sit down and talk. And when they raise such issue and say, Daddy, Mommy is saying, let's sit down and talk, you have no choice as a head of the family, if you want peace in your home, to sit down and talk and then resolve the issues. And everyone is happy that the issues are addressed. So I think that this time around, I have this belief that there is no way these matters cannot be addressed, and addressed in a satisfactory manner, especially with regards to those issues they have raised. They are very fundamental. I don't have a car. The cars that are bought, maybe refurbished, second-hand, breaks down. You want to send me on a course, I should be able to have a backup assistant that will go with me, because that has been the procedure. I need to have light. I need to have internet for my chambers and in my home. For me to work as a judge of the Supreme Court, I need to have these, fundamental things. I need to have light in order to, write my rulings and proceedings. You don't ask me to leave the Supreme Court by 4 p.m. That is a height of degeneration. I mean, these are issues. And if you look at those issues, there are issues that I think that the CJN we sit down with the fellow justices and address, for the sake of the country, for the sake of administration of justice, and also for the stakeholders generally. That is what I think. And I think after this matter has been raised publicly, that there will not be any such further brouhaha, from now onwards. That's my thinking. And I don't think that we'll come to the level where justices will begin to carry placards or begin to boycott court. That would be the...
Yeah, but should we just leave it at that level? I mean, this was unprecedented.
I agree.
Yes, the Chief Justice has also replied, citing, he's also used pretty strong words, talking about how judges in all climes are to be seen and not heard, and how this is dancing naked in the market.
Yes.
I mean, he's also used those kinds of words. But looking at what we have seen, and there's also a lot of other external factors. There are people who have been trying to snoop around to find out, because of course the Supreme Court justices will not speak to you, judges will not speak to you.
That's right.
So you have to find out from around the courts what precisely could have led to this. And when you begin to hear those kinds of stories, you have to ask whether enough checks and balance have been put in place in the judiciary to ensure this accountability and probity. It's not going to happen by accident. Should we be taking a second look at how our judiciary is set up, with the idea to ensure that there is sufficient check and balance within the judiciary as an institution?
I certainly share that view. And as I said earlier, the conversation is gearing towards that angle, that, yeah, we are talking about insufficiency of funds. Now, when the funds are also released, no matter how little, what do we do in terms of accountability? What do we do in terms of disbursement? Are we putting it in the right place? Are we ensuring equitability, even in the sharing of the resources? So Now, some of them form a team. They have a team, that looks at that disbursement, not necessarily now the chief judge or the CJN being in charge solely. Because, I mean, he can, if he's in charge, issue of likelihood of abuse, will be there. So checks and balances must be made available in the system. And I can assure you.
I hear you when you say that they form a team.
Yes.
Well, some people will say that that is an ad hoc measure, something that might serve in the meantime.
Yes.
But we know, for instance, in the National Assembly, that there is Public Accounts Committee, where the effectiveness of that, committee is, is left for anyone to decide. But it's there. It's a statutory committee set up by the Constitution,
yeah,
which the National Assembly must have. And the way it works is that it's usually chaired by a member in the opposition to the government of the day. The executive arm of government is checked by the legislature oftentimes. Should we be looking at some constitutional checks for the judiciary as well? Maybe also another intervention by another arm of government when such a situation arises?
In fact, there has been suggestion by senior lawyers that get the judges off, in terms of deciding funding and issue of finance. Let a statutory body be created that will be in charge of the money whenever it comes. Because it will be very, very, very wrong and very sad for judges to be accused of corruption. I mean, these are people that play the role of God in a society in terms of dispensing justice, and then tomorrow you are now accusing that person of being enmeshed in corruption, especially monetary corruption. So they are saying, look, let there be an administrative body that can deal with this issue of fund, not necessarily the judges, not necessarily the chief judges or the chief CJN. That has been the suggestion by many lawyers. And from the look of things, with this conversation that is ongoing, I think that it will come to that level where a body will be created statutorily for dealing with financing that come from, from the budgetary allocation. Yes.
As you wind down,
yes,
just as you suggested, because some will interpret this as an accusation of maladministration on the part of the CJN. So how this body of benches team that they're setting up now, are they going to provide what? A short-term solution? Because the most that will happen is CJN answers to their request. But in the interest of the country and the judiciary,
yes,
what should specifically be done urgently to ensure this never happens again?
I agree with you. You see, everyone is listening. I'm sure that the members of the House, they're taking note of what is going on presently. If there is any lacuna somewhere in terms of, providing this body that can probably be in charge of the finance of the judiciary, they have to look into it. Issue of transparency has become an issue. As I said earlier, the AG raised it. He said, look, we have improved on our budgetary allocation, but you are not being accountable. You are not being transparent. So try as much as possible, because they ask for account, they are not returning. There is no return even to the members of the House. So issue of accountability now is because, so everyone is listening, the executive is listening, all of us are listening. We who are also involved. As I said earlier, there are many issues we need to talk about judiciary. The Supreme Court, we need to make it a regional one. This issue of every matter going to Supreme Court, you have up to 10 years to get a date. It's not something all of us should be very happy about. People are complaining. Litigants are complaining. Now, what they even give priority is only criminal cases. What of the civil case? I'm in court in order to have my matter addressed, my grievance addressed. And you're telling me I have to wait up to 7 years in order for that matter to be disposed of. It's not helping those who believe in judicial system. So there are issues. And the earlier we address it, the better. And I think everyone should be involved, including the press. You guys are doing a lot. Let's get our administration of justice going. It's not running well in the country. And that is the truth.
Very quickly, Sullivan, what's the sentiment within the judiciary? Are they embracing these calls for independent supervision of the funding?
Yes, they have no choice. It's issue of law. Let's put a law in place. It will help them, and also save all this set of embarrassment also on the judicial officers. It's very important.
Thank you very much indeed, Mr. Mondo Ubani, Chairman Speedel. We hope Speedel is doing well, and former second Vice President of the NBA. We're back in a moment. Don't go away.